Hello and welcome to part 2 of our webinar series on furlough fraud. I'm here with Emily Moore. Hello, Emily.
Hi, Sara.
Who's a colleague in the employment team here at Hare Court. You may have seen our first video, which is on furlough fraud and what constitutes fraud. Today, we're going to be focusing on what do you do if you've made a genuine mistake. Emily, I think you have some points to start us off for what people should be looking to do.
Yeah, sure, Sara. So I think it's worth noting at the outset that the furlough rules were very complex and sometimes quite ambiguous. So simple mistakes may quite easily have been made. For example, miscalculating hourly pay or making mistakes in relation to holiday periods. So it's fair to say that the capacity for human error was quite considerable. So if employers think a mistake might have been made when they were filling out the application form for CJRS support, the starting point really should be to seek advice from their tax advisor or a lawyer without delay. The tax advisor can then notify HMRC and liaise with them regarding the sums that might be due and the deadlines for repayment. So in terms of timing, companies were given the chance by HMRC to rectify their mistakes without being penalised, but they were given a narrow window for doing so. And this was called the notification period. And it was essentially the latest of the following. So 90 days after the date that the grant was received, or 90 days after the circumstances changed, resulting in the company no longer being entitled to receive the grant, or the 20th of October, which is the so-called amnesty date introduced by HMRC. Now, as at the date we're filming this video, the 20th of October has now passed, and it's not entirely clear how lenient HMRC are going to be to companies who have missed that deadline. But I think it's safe to say that certainly there is a risk that if you have not notified your mistake by the 20th of October, then there is a risk that you'll face a full-scale investigation. So Sara, what will HMRC do in the event that there has been a mistake in payment?
Thank you, Emily. I think this is quite important because HMRC can recover in full the overclaimed amount by way of a tax assessment, which has to be repaid within 30 days, and late payment penalties can be charged. So they may also charge a penalty of up to 100% of the amount of the CJRS wrongly received as a punishment for not notifying them of the overclaim in that notification period that you've helpfully talked us through. Importantly, failure to tell HMRC of the overpayment within the notification period is deemed to be deliberate and concealed, and this is the starting point when addressing the amount of the penalty. Is there anything else we should know about HMRC's approach, Emily?
Yes, Sara. So I wanted to mention that HMRC can, as well as seeking repayment from the company itself, can also seek repayment and penalties against individual partners of a partnership and company officers of insolvent companies. So, for example, directors need to be aware that they could personally be held liable, not just the company. And I'd also say, just by way of general advice, that the bottom line really is that if the company has not already done so, if they claimed under the furlough scheme and there are any suspicions as to potential mistakes having been made, they need to be auditing their payments made under the scheme ASAP to highlight any potential irregularities. They need to be taking legal advice if they're unsure. And above all, they need to make sure that they're not simply turning a blind eye. So it's extremely important to be acting as quickly as possible and following HMRC's guidance, which is readily available online.
Now, there are a couple of conclusions that I would like to draw, Emily, on this topic, because what we have seen so far in terms of investigation numbers is only the tip of the iceberg. What we do know is there is going to be high public pressure to recoup money that's going to have been paid out fraudulently. And we know that where, for example, HMRC have had to crack down in other areas of fraud, with items such as benefits, you always get very, very strong public pressure, and we see no reason why this would be any different. And in fact, where there has been such a demand for public money, if it is being misused, there is going to be very strong support to claw that back. But there are also other schemes that we haven't touched upon so much in these two videos. For example, the coronavirus bounce back loan scheme, the coronavirus business interruption loan schemes, and they no doubt are going to have suffered from the same problems that we have been talking about in terms of the potential for fraud. Now, the National Audit Office has estimated as much as 26 billion could have been paid to fraudsters under the CJRS. So we know that there is a real incentive for HMRC to investigate and to properly work out where there have been incidences of fraud. So I think we both agree, Emily, on this, that where there has been any mistake, where there is any uncertainty on the part of an employer, it really is within their interest either to go to a tax advisor, and if they think it is important, to seek legal advice as well, because the kinds of penalties that could attach not just to the company, but as you've pointed out, to individuals in their role as company officers, etc., could mean that there could be some very harsh penalties. So on that note, we're going to conclude this video. Thank you very much, Emily.
Thank you, Sara.
And thank you to everybody for watching. We hope you found it informative.